Good evening. If you are joining us from Europe, good morning, good afternoon, good evening. If you are joining us from anywhere else in the world, or indeed listening to this as a recording at a later point. My name is Martins Paperinskis. I am a reader in public international law here at UCL Laws, and I'm a host of this year's first Current Legal Problems lecture. Current Legal Problems is a flagship lecture series of UCL Laws taking place this year for the 74th time, and in it we showcase exceptional external speakers as well as our colleagues' inaugural professorial lectures. I'm one of the co-editors of CLP series together with Sylvie Suteu and Paul Mitchell, and at the end of each year the lectures are collected and published by Oxford University Press. My role as a host is a limited one. I introduce the concept of CLP that I have done, and then I introduce the chair who does everything else organizationally speaking. But before doing that, I cannot help but note, since public international law is a topic of today's talk, that this has always been a particular strength of CLP and UCL. Looking back to the very first year, I noted that out of 13 speakers, 3 were public international lawyers. Judge Cheng, Albert de la Pradelle, and of course, inescapably for UCL, Georg Schwarzenberger. So public international law has been with us for a long time. I'm very privileged and pleased to be able to introduce Sir Michael Wood as the chair for tonight's talk. Sir Michael is a barrister at 20 Essex Street Chambers. Sir Michael was the principal legal advisor of the Foreign and Commonwealth Office from 1999 to 2006. And I suspect that papers related to today's discussion may have crossed his desk once or perhaps even twice during those years. Since 2006, Sir Michael has done many great things in public international law. I would particularly like to single out his counsel work before all the great international courts, including the International Court of Justice, and of course his work at the International Law Commission as the special rapporteur of the topic that was eventually expressed as identification of customary international law, pragmatic, sound, and accepted by states and international tribunals. We are privileged to have you, Sir Michael, as tonight's chair. Sir Michael, the floor is yours.
Martins, thank you very much for that kind introduction. It's a great pleasure to chair this important lecture at UCL, one of the great centers in England for public international law. It's an even greater pleasure to introduce Professor Monica Hakimi from the University of Michigan Law School at Ann Arbor. I have very happy memories of visiting the University of Michigan on a number of occasions. It's one of the best law schools in the United States for public international law and one of the most agreeable, and I strongly recommend it to anyone who's thinking of spending some time in the United States. Now, Monica's theme is what might finally kill the jus ad bellum. I'm very grateful to Monica for calling it the jus ad bellum rather than the jus contra bellum, which seems to be rather fashionable in Europe at least. I think the jus ad bellum is still the most important subject of international law. It's one of the reasons why we should all care about international law. And I very much hope that Monica's words this evening will help to ensure that the rules on the use of force are not killed off and have a bright future. So without more ado, I'll invite Monica to unmute herself and start delivering her lecture. Thank you.
Great. Thank you so much, Sir Michael and Martins, for having me here, and to all of you in the audience for tuning in. It's really delightful to be here. So the UN Charter turned 75 this year. When it was signed in the final months of World War II, it was an absolute game changer for the jus ad bellum. the body of international law that governs when states may use force across national borders. And while it has never worked exactly as it was supposed to do, it has persisted as a meaningful form of regulation since 1945. Its 4 central tenets on the use of force are still with us today. First, and at the most basic level, decisions to use force across national borders are not entirely within the discretion of individual states. Use of force decisions are regulated by international law. Second, states may not use force to settle their petty grievances or advance their nationalistic agendas. Article 2.4 of the Charter prohibits states from using force, and I'm quoting, against the territorial integrity or political independence of any state or in any other manner inconsistent with the purposes of the United Nations. That language has long been understood to prohibit any use of force by one state in another without that latter state's consent. Third, the UN Security Council is the principal locus of decision-making on the use of force. Despite the general prohibition of Article 2.4, the Council has broad discretion to use force in the service of international peace and security. Last, states also have a limited right to use force unilaterally, that is outside the Council, when necessary to defend themselves. These 4 tenets are very bare bones, so they have a lot of play in the joints. There have been persistent questions and debates about how they cash out in concrete situations. And yet they have persisted through the Cold War, past the supposed end of history of the 1990s, and well into the 21st century, when the security challenges most on the international radar screen have concerned transnational terrorism, weapons of mass destruction, and cyber warfare. So one might use the occasion of the Charter's 75th birthday to celebrate its remarkable durability and impact on the use of Bellum. But to be honest, I haven't been in the mood to celebrate, and it's not, or at least not only because I'm a grouch. I'm seriously concerned that as the Charter rounds 75, its framework for regulating the use of force is on life support. I don't say this lightly. I know that there is a long tradition of international relations and legal scholars warning of the irrelevance or demise of the Charter system. In my view, those warnings have been wrong. The reason they have been wrong is that they have misdiagnosed the threat, or at least they have myopically focused on and overstated the seriousness of a particular threat. They have assumed that what most threatens the Charter system are acts that violate it, acts that contravene Article 2.4 and are not authorized by the Security Council or taken in self-defense. In focusing so intently on rule violations, I'll argue, these scholars have diverted attention away from the kinds of challenges that might actually push the use of Bellum to the breaking point, and that I think we now confront. So to persuade you that previous warnings have been overdrawn, but this one today should be taken seriously, I want to start with the misdiagnosis, that the biggest threat to the Charter system, the thing we should most worry about if we want to preserve it, are acts that violate it. To explain why that worry is overdrawn, I'll give you an account of how I think the use of Bellum actually works, what in my view has kept it ticking and allowed it to persevere despite the evident disharmony that we observe in its day-to-day operation. This account of how the use of Bellum works should help us see why it might stop working. Then I'll identify 3 trends that in my view strain the system. And I'll explain why these 3 trends are, maybe alone, but certainly in combination, real cause for concern. To start, what's the idea behind the misdiagnosis? The idea is that in order for the use of Bellum to be working, it must constrain as much as possible when individual states resort to armed force. The more strictly states adhere to Article 2.4, and the more they thereby refrain from unilaterally using force, the more obviously the use of Bellum is working. Conversely, if states violate Article 2.4 and use force outside the Council without having been attacked, the use of Bellum must not be working. It must not be doing enough to constrain unilateral force. In this theory, violations of Article 2.4 are almost per se evidence that the Charter system is not working. The more states violate Article 2.4, the more the use of Bellum must be failing. At a certain point, it fails often enough that it just seems obsolete. Thomas Frank has presented what is perhaps the most well-known and trenchant version of this idea. In 1970, Frank argued that Article 2.4 had been, quote, eroded beyond recognition. And now I'm quoting again. What killed Article 2.4 was the wide disparity between the norms it sought to establish and the practical goals the nations are pursuing in defense of their national interests. In other words, states too often violated Article 2.4 in order to advance their own interests. For Frank, the repeat violations of Article 2.4 killed not only that prohibition, but with it the entire Charter system. Quote, the failure of the UN Charter's normative system is tantamount to the inability of any rule, such as that set out in Article 2.4, in itself to have much control over the behavior of states. The fact that Article 2.4 could not control states, that they kept violating it, betrayed its failure. Frank rang the death knell again in 2003 after the United States and the United Kingdom put together a so-called coalition of the willing to invade Iraq. Quote, Article 2.4 has died again, and this time perhaps for good. Frank argued that Article 2.4 was, quote, miraculously reborn after the Cold War, but the 2003 Iraq War was, in his view, patently unlawful and evidence that the United States was simply not willing to accept any constraints on its behavior. And for Frank, this meant that the Charter was again dead. Quoting, instead of the law of the Charter, we find an unabashed return to the principle that the strong do what they can and the weak suffer what they must. There is no law here. Others have made similar claims at different points in time. And indeed, with each significant deviation from Article 2.4, international lawyers warn about its impending demise. You might remember that in 2017, the United States attacked a Syrian airfield after evidence surfaced that the Syrian government had used chemical weapons against its people. Most international lawyers claimed that the US action plainly violated the Charter. The United States did not act with Bashar al-Assad's consent. It did not have the UN Security Council's authorization, and it was not acting in self-defense. Analysts thus said that we were again witnessing the, quote, slow degradation of Article 2.4. For example, Anthea Roberts took issue with the suggestion, quote, that states can violate international law and yet simultaneously seek to preserve the Charter prohibition. The system does not tolerate one-off violations, she indicated. Whether we like it or not, one violation begets others, pushing Article 2.4 into obsolescence. Fionnuala Nialan said something similar. The US action in Syria, in her words, quote, underscores the ongoing erosion of the UN Charter norms on the lawful use of force under international law and weakens the Charter system. The idea is that if the Charter hadn't died by 1970, and if it didn't die in 2003, then it gets, with each new violation, sicker and weaker than it had been before. The thing to worry about if we want to preserve its framework for the use of Bellum are acts that violate it. This idea that violations of Article 2.4 are ultimately what kill it is, in a technical sense, correct. Law isn't static. It's a social construct. It's created and given what life it has through the social interactions that put it at issue. All law, and the use of Bellum is no exception, shifts in ways large and small depending on how people engage with it. So although the Charter text has not changed since 1945, its operative content undoubtedly has. If you want a concrete example, here's an easy one. Article 2.7 provides that, quote, nothing contained in the present Charter shall authorize the United Nations to intervene in matters which are essentially within the jurisdiction of any state. In the early days, there were serious questions about the extent to which Article 2.7 constrained the UN's authority to address matters that were domestic in nature. Those questions have mostly evaporated. UN organs intervene all the time, including by authorizing force, in matters that were once considered to be essentially within states' domestic jurisdictions, most notably in civil wars. So it might be correct to say that the Charter system as it existed in 1945 is dead. It has, by almost all accounts, changed since then. But that's not quite what Frank and the others mean when they claim that Article 2.4, and by extension the entire Charter system on the use of Bellum, are dead or infirm due to the many acts that violate it. And this claim is deeply misleading. Well past 1970 and well past 2003, states have invoked and relied on the Charter as law. They have persistently used it as a source of authority to orient their interactions on the use of force, and most of them have refrained from using force as a routine instrument in their foreign affairs. The claim that the use of Bellum died fails to account for all the ways in which it has continued to live. To hit the point home, imagine that it's 2005 and you're a practicing international lawyer. A client asks for legal advice about a particular operation involving the use of force. Maybe the client is herself contemplating the use of force, or maybe she wants to respond to a use of force by someone else. Advising her that there is no law here, that per Frank, all we have is the principle that the strong do what they can and the weak suffer what they must, would be deeply misleading, bordering on malpractice. The client would be badly burned if she relied on that advice to say or do anything on the world stage. She would rightly wonder why other global actors talked and acted as if the Charter was law. The fact of the matter is that in 2005, states and other actors still use the Charter as law. To say that it died is to say that it no longer structured global interactions on the use of force, and that claim would be, as a descriptive matter, wrong. If we want to be more clear-eyed about the Charter and whether it is healthy or infirm, we need to figure out what that analysis gets wrong. Where does it veer off course? I think there are two significant problems with it. The first is that even on its own terms, it is too broad. Let's assume with those who advance this claim that the use of bellum is ultimately about constraining unilateral force and that it for all intents and purposes dies when it stops doing that. It is not clear to what extent the violations that have occurred betray an overall lack of constraint. It seems more likely that the Charter has constrained some uses of force and some governmental officials, but not others. For example, perhaps the Charter has effectively constrained conduct that hits at the core of Article 2.4, large-scale invasions or annexations of foreign territory, but has been less effective on lower level or indirect uses of force. If the metric for evaluation is the occurrence of a violation, then all violations, from the full invasion to the small incursion, have the same deleterious effect. But that's just not how law works. When a state decides not to prosecute people for negligent homicide, it doesn't for that reason open the door to mass slaughter. Not all violations are the same. Further, even with respect to the same kind of conduct, one violation does not necessarily beget others on a one-way ratchet toward death. Norm theorists have argued that what matters, for purposes of preserving or adapting a norm, is less whether the norm is violated than how people react when a violation occurs. For example, if enough people rally behind the norm in the face of a violation, the incident could in fact strengthen the norm. Likewise, and now I'm quoting the International Court of Justice, if a state acts in a way prima facie incompatible with a recognized rule, but defends its conduct by appealing to exceptions or justifications contained within the rule, the effect is to confirm rather than to weaken the rule. The point is that the claim the violations portend death is too simplistic. It needs to be substantially refined to be taken seriously. And let me be perfectly clear here. I'm not saying that violations have no effect on the law. I'm saying that while certain violations might cause Article 2.4 to change or deteriorate, the claim that every violation or every significant violation necessarily evinces its across-the-board erosion is not substantiated. If anything, the evidence points in the other direction. The second problem with that claim is more conceptual. Warnings about the demise of the use of bellum almost always assume that it ought to work in a particular way, that it ought to constrain as much as possible when states use force unilaterally. Then when it doesn't work as analysts think it should, they posit that it must be failing. They use their conception of how the use of bellum should work to assess whether it is working. Their method of analysis is circular. All they can tell us is whether the use of bellum is working as they think it should. If we want to understand whether the use of bellum is actually working, we need to start not with a normative theory of how we think it should work, but with a positive theory of how it does work. By understanding how the charter system works, we might make some headway in identifying why it might stop working, what might actually cause it to die. A few years ago, Jacob Katz-Kogan and I presented such a theory. We aimed to explain the combined resilience and disharmony in the use of bellum, the fact that the charter system has persisted over time, even though it has been, from the beginning, highly discordant in its operation. Our theory, in essence, was that the use of bellum is best understood as a site of ongoing contest and compromise between two very different visions for the charter. These two visions, what we called codes, prioritize different procedural and substantive norms and had different bases of support. And they push the charter in opposite direction. The competition between them creates an inherent tension that often manifests in uncertainty or incoherence. What has kept the system going, however, is that neither code has completely boxed out the other. The key proponents of each have instead found ways to accommodate and create space for the other so that they can together comprise the use of bellum. This might sound highly abstract, so let me unpack it. One vision for the charter, what we called the institutional code, is established primarily through international institutions, most notably the UN Security Council, the UN General Assembly, and the International Court of Justice. On substance, these institutions push toward constraining unilateral force and centralizing decision-making at the Council. And their pronouncements have an inherent authority that derives from the collective and structured processes through which they make decisions. Because of this authority, the institutional code's norms are what most international lawyers would define as positive law, the real jus ad bellum. For example, analysts who asserted that the 2017 action against Syria was unlawful mostly assessed it by reference to the institutional code. But of course, international institutions do not have mechanisms to implement their own vision for the charter. They carry authority, but they don't have control. The jus ad bellum's material dimension, its control, resides in the hands of individual states. And when individual states act outside the structured channels of international institutions, they as a group are much more tolerant of unilateralism. A second code, the state code, kicks into gear when states act or react in unstructured ways in concrete cases. The state code persistently produces substantive norms that push in the opposite direction of the institutional codes, toward loosening the constraints on unilateral force and shifting decision-making from the council to states that act outside of it. Because this code reflects what states do and tolerate in particular cases, it sets expectations about which norms will be implemented, which have operational power. So while the institutional code has authority but lacks control, the state code has control, but as a general matter, it is on its own deficient in authority. In other words, states acting outside international institutions have a very hard time establishing full authority for their policies when these policies contravene what the institutions have said. Most international lawyers would declare such policies to be unlawful. Now, it's easy to say, as many people do, that states on the whole prefer the vision that the institutions promote, which again is one of constraint and centralization. I think that's probably true in an abstract sense, but I'm not sure it's true when the rubber hits the road and states actually have to make difficult and imperfect decisions about real life problems. The hard fact is that most states do not consistently advance the institutional code's restrictive policies. The same states that endorse those policies in institutionalized arenas often support or at least tolerate the state code's policies in the context of specific incidents. The 2017 Syria case is again illustrative. Although most scholars insisted that the US action was unlawful, by which they meant that it contravened the policies of the institutional code, the vast majority of states either openly supported or expressed some ambivalence about it. There might be multiple reasons for the discrepancies between what states say in international institutions and what they say and do outside of these institutions when confronted with real life problems. For example, states might react to an operation not on the basis of a generalizable principle, but because of the particular issues at stake. They might lack sufficient interest in any given case to express their views, or they might have multiple context-dependent and conflicting interests, such that some are best advanced through international institutions, while others are not. Whatever the reasons and however unfair the results, the policies that are pronounced in institutional settings are not the same as the ones that are implemented and tolerated outside of them. So while states participate in both codes, the main drivers of the institutional codes are not states per se, but the institutions that structure their interactions in support of its own restrictive policies. Meanwhile, the main drivers of the state code are the states that regularly use their militaries to shape world affairs and tee up forcible operations for other states to deal with. The point of this analytic scheme is to underscore that there is a constant tension between the founts of authority in the use of Bellum, institutional code, and the levers of control, state code. This tension is baked into the charter system and regularly manifests in concrete cases, such as the 2017 Syria one. It helps explain why the system is so volatile, why actual or perceived violations are so common. To crystallize the point, Frank was correct when he said that there is a, quote, lack of congruence between what many international lawyers say is law, institutional code, and what many states decide and practice to do with the law, state code. But Frank was incorrect to suggest that that incongruence was by itself enough to break the system. The incongruence is instead built into the system. It has been a constant feature of the use of Bellum. What has ultimately kept the system ticking in the face of this incongruence is that the key backers of each code have, while pressing for their own vision, still preserved space for the other. After all, each code brings something important to the use of Bellum: authority from the institutional pronouncements, and materiality from states' operational practice. The system as a whole benefits from having both. This is not to say that both must be on display in every single incident, but the charter system must have enough authority so that use of force decisions do not seem just like expressions of raw power, and it must have enough control so that authoritative pronouncements do not seem like utopian pipe dreams. In brass tacks terms, even as the two codes compete for preeminence within the use of Bellum, they in a very real sense still need each other. The key participants have historically attended to this fact. They have to varying degrees relied on and accommodated each other. The constant dance between them, between the bases of authority and the levers of control, is what has helped to preserve the system, given the evident disagreements on policy and process. The specific moves in the stance vary by context. They depend on what the key players in each code want and what they are willing to do to get it. In some contexts, there's not much need for compromise. The institutions with authority and the states with control share the same basic policy goal, so they can work seamlessly together. Take a case involving the Security Council's authorization. The Council, part of the institutional code, confers authority on an operation. Individual states then work through the mechanisms of the state code to implement the operation. In this dance, each code supports the other. The Council's pronouncement does not seem utopian because states make it operationally relevant. Meanwhile, the states that use force don't look like they're just flexing their own muscle because the institutional support for their operation gives it authority. Yet even in these cases, we often see fissures between the founts of authority and the levers of control. You might remember the controversy when the NATO-led operation that intervened in Libya, pursuant to Security Council's authorization, decided to depose Libya's longstanding leader, Muammar Gaddafi. The legal debate centered on the apparent gap between what states did with their military power, state code, and what the Security Council had authorized them to do, institutional code. In many other situations, the fissures between the two codes are much larger. Each code advances a competing policy, and yet they still find some way to dance to preserve space for the other. Take the 2017 Syria incident. The United States did not deny that the institutional pronouncements are law. It accepted and did not challenge their authority, but it also did not make them operational. It implemented a different policy. In the face of this normative contest, each code was given space to do its own thing. The institutional pronouncements continue to establish the standards that are, as a general rule, accepted as authoritative. They made it harder, some would say impossible, for the United States to claim that it was acting lawfully. But the state code implemented an alternative policy for the facts. The United States did what many states suggested needed to be done. The discordance between that which is accepted as authoritative and that which is accepted as controlling is, of course, disorienting. But, and this is the critical point, it also means that each code is playing a role in the use of Bellum. Each matters, they just matter in different ways. One brings authority, the other brings control. Okay, so that's the theory. How might this theory of how the use of Bellum works help us diagnose whether it is ailing? Well, as I said, it suggests that there must be room in the use of Bellum, both for the authority that comes from the institutional code and for the control that is inherent in the state code. Without meaningful doses of each, the system as a whole becomes decrepit. And that's what I think we're beginning to see. I want to outline 3 trends that are together working to box out the policies and processes of the institutional code, such that across a broad spectrum of scenarios, the use of Bellum's authority seems irrelevant or absent, and what really seems to matter are only the levers of control, raw power at the expense of authority. First, some militarily powerful states are now advancing very sweeping claims on self-defense. Entire books can be, and indeed have been, written on the topic, so I'll have to make a long story short. After the September 11, 2001 terrorist attacks, the United States started advancing 2 distinct claims that define expansively the right of self-defense. One is for scenarios like 9/11. The United States contends that a state may act in self-defense against a non-state actor in another state, so long as the territorial state is unable or unwilling to address the threat. As this claim has been articulated and applied, the victim state has broad discretion to decide that the territorial state is unable or unwilling, and then to act unilaterally in its territory on that basis. The United States has also advanced an expansive claim on anticipatory self-defense. The claim is that a state may act in self-defense not only, in the words of the Charter, if an armed attack occurs, but also if an armed attack might in the future occur. The US test for when a state may act anticipatorily is multifactored and its outer bounds are poorly defined. But it's clear that in the US view, a state may use defensive force not only when the anticipated attack is temporally immediate, on the verge of occurring as in a troops marching toward the border scenario, but also when attack is more conjectural and the threat more latent. Both of these claims had seeds in the pre-9/11 practice, but they've become much more pronounced since then. At this point, about a dozen states, mostly military allies of the United States, such as the United Kingdom and Australia, expressly endorse one or both of these expansive claims on self-defense. This group of states has also repeatedly acted on their claims, and when they do, the responses from other states, outside institutional channels, are mostly silent and sometimes even supportive. In other words, states that act on these claims face minimal normative or material repercussions for their conduct through the state code. Why is this dynamic a problem? The misdiagnosis that I discussed earlier, the idea that what most threatens the use of Bellum are acts that violate it, does not help us answer the question. The law on self-defense, particularly in the context of attacks by non-state actors, is unsettled. There is an ongoing contest about when, if ever, states may use defensive force in the kinds of situations that the 2 claims are designed to cover. And so it's not clear to what extent the operations that have been conducted pursuant to these claims violate the law. For what it's worth, Thomas Frank argued that self-defense against non-state actors was generally lawful. Such operations would not, in his view, violate Article 2.4, so they would not, by his metric, be for cause for concern. I think they are a cause for concern. The reason why is that they reflect an effort by those who have military power to sideline the relevant institutions and the authority that they bring to the use of Bellum. The institutional pronouncements, both on self-defense against non-state actors and on anticipatory self-defense, have not been entirely consistent and are often cryptic. Still, none of the universal institutions has endorsed the expansive claims that are now on the table. If anything, the institutions express significant discomfort with these claims and on the whole push in the opposite direction. That discrepancy between what the institutions pronounce and what militarily powerful states do is, of course, consistent with the descriptive theory that I articulated earlier. International institutions push in the direction of constraint and centralization, while states acting outside of them push toward discretion and decentralization. But here, those who are in control leave very little room for those who have authority. Unlike in the 2017 Syria incident, the states that are making operational decisions are not deferring to the relevant institutions to establish the policies that are in general authoritative. They are claiming that they get to decide, mostly through their own horizontal and decentralized interactions, which policies are authoritative. And they are claiming authority not just for one operation, as in the Syria incident, but for a whole slew of them. If their claims on self-defense were accepted, and this is particularly true of the claim on anticipatory self-defense, states would have discretion to use force unilaterally in an extraordinarily broad range of circumstances that would otherwise be subject to the Security Council's decision-making. To use the two codes framework, the expansive claims on self-defense represent a significant push toward unilateralism, the impulse of the state code, without accommodating the countervailing policies or attributes of the institutional code. And that's what's damaging to the use of Bellum. Notice that my claim here is descriptive and analytic, not normative. I'm not casting blame on the military powerhouses that advance the expansive claims. Their claims address threats that are real, and other states have not meaningfully stepped up to the plate. Most have been wishy-washy in responding to these claims, occasionally supporting actions that are undertaken pursuant to them, often staying silent, and at times expressing discontent. What's more, it's hard to craft a legal standard that strikes exactly the right balance between discretion and constraint. But we should appreciate, without casting blame, that the dynamic is unhealthy for the use of Bellum. About a dozen militarily powerful states are claiming for themselves the prerogative to define the law. They are defining it in ways that would significantly expand their discretion to use force and would further undermine the role of international institutions. And they are regularly acting on their own claims. They are doing so without the affirmative support of most other states and in contravention to some of the institutional pronouncements. This dynamic calls into question the extent to which the military instrument is still subject to collective regulation, the extent to which use of Bellum's authority has a life that is independent of what militarily powerful states are willing to do. The second trend is more embryonic, but I think gaining steam. It is a retreat from the norm that lies at the very heart of Article 2.4, the prohibition on acquiring territory by force. Since 1945, this norm has not seriously been in doubt. The reason why is that it has had both institutional and operational support. International institutions have repeatedly affirmed the prohibition of territorial conquest, and states acting independently have implemented it. Of course, states have also at times violated this prohibition, but the violations have been rare and have been treated by almost all of the relevant players as violations. When Iraq invaded Kuwait in 1990, the Security Council authorized and a coalition of states implemented a military operation to kick it out and thereby to restore Kuwait's territorial integrity. When Russia annexed Crimea in 2014, the UN General Assembly condemned its action. The Security Council would have done the same if not for Russia's veto, and several states acted on their own to impose sanctions on Russia. Moreover, Iraq and Russia each denied having violating the prohibition. Iraq tried to characterize its action as consensual, and Russia is realizing the Crimean people's right to self-determination. The violating states thus conceded, even if only implicitly, that a forcible annexation would be impermissible. In the past few years, a handful of states have more openly used their raw power to acquire territory, and the reactions have been more ambivalent. In 2019, India revoked a provision of domestic law that granted autonomy to the portion of Kashmir that it administers. India also took other measures to tighten its material control in the area. As sovereignty over Kashmir is contested, India's moves look like an effort finally to annex this part of Kashmir and incorporate it fully into India proper. That presumably is why UN Secretary General Antonio Guterres underscored that Kashmir's final status, quote, is to be settled by peaceful means in accordance with the Charter of the United Nations. Also in 2019, Turkey openly invaded Syria to establish a Turkish-administered safe zone across the border. Israel, which had long denied any intention to annex unilaterally the territories that it occupied in the 1967 Arab-Israeli War, has started talking openly about doing just that. And this month, Azerbaijani forces went on the offensive with Turkey's strong support to recapture territory that Armenia seized during the Nagorno-Karabakh conflict that culminated in a ceasefire in 1994. Azerbaijani and Turkish officials have said that force was an acceptable instrument for reclaiming the contested territory because negotiations had stalled out. I don't want to overstate the point. These incidents are still somewhat tempered relative to classic invasion and annexation scenarios. Each arises out of a long-standing territorial dispute, and each has generated some international censure. But together, I think they suggest a renewed willingness to try to gain control over contested territory through the threat or use of force. They challenge the material relevance of Article 2.4 at, or at least very close to, its core, with respect to the prohibition of territorial conquest. Meanwhile, the US government is no longer playing the outsized role that it historically has played to bolster this prohibition. Although the United States offered to help mediate the situation in Kashmir, it quickly let the issue go when India rebuffed its offer. It facilitated Turkey's invasion of Syria by abruptly withdrawing its own troops from the region without any plan to fill the vacuum. It has encouraged Israel's annexation of the West Bank, East Jerusalem, and the Golan Heights, and it has made only minimal efforts to address the Azerbaijani-Armenian conflict. In particular, it seems unwilling to pressure Turkey, a NATO member, to stop fueling the fire. It's easy to chalk up America's newfound ambivalence to Donald Trump's chaotic style of governance, but Trump is not, in my view, the only thing going on here. America's geopolitical position is clearly changing, and the American public is, I think, getting more and more weary of our military adventures. To put the point bluntly, it's increasingly unclear to what extent the country remains invested in its outsized military footprint or would partake in an extensive war to defend other countries from attack. The US security umbrella is simply not as strong as it once was. To the extent that this umbrella has helped to deter some of the most egregious acts of aggression, those that go to the core of Article 2.4, that deterrent seems to be weakening. Let me bring this back to my analytic frame. The US security umbrella and the longstanding US policy of trying to lead on global security problems are features of the state code. These features have historically bolstered the prohibition of territorial conquest, which is still by all accounts authoritative, by helping to make it operationally relevant. Without this lever of control, the prohibition standing in the state code is more at risk. Unless other actors are willing to fill this space, we can expect to see more efforts to acquire territory by force. In other words, we can expect to see a further deterioration of this prohibition within the state code. Here again, the misdiagnosis and its obsession with violations is insufficient to capture the problem. For example, nothing requires the United States to play its historic and outsized role on these issues. A significantly smaller US security footprint would be perfectly consistent with international law. Moreover, and now I'm just repeating myself, not all violations are the same. The fact that states sometimes use force in contravention of the institutional pronouncements is not new. Discrepancies between the norms that are authoritative and the ones that are operationalized are routine features of the use of Bellum. It is, again, a baked-in component of the use of Bellum. What's troubling is that this particular discrepancy cuts at the heart of the use of Bellum. It is emerging not at the periphery of Article 2.4, for example, with respect to indirect uses of force, and it is not in the service of other deeply held international legal norms, such as the prohibition of chemical weapons. It reflects the pursuit of old school nationalistic claims to territory. So it calls into question the relevance of the use of Bellum's authority at or close to its core. If the use of Bellum's authority does not work to constrain states, even from claiming territory by force in the pursuit of their own nationalistic agendas, what does it constrain? Is military power really the only thing that matters? The third and last trend that I want to discuss is unlike the other two in that it is entirely discursive in nature. States that use force contrary to the authoritative positions that the relevant institutions have pronounced decreasingly try to accommodate those positions. They are less invested in the discursive dance. Go back to the 2017 Syria incident. Remember that I used the incident as an example of a relatively healthy dynamic once we take the discrepancy as a given. The United States did not ignore or challenge the authority of the institutional pronouncements. It conceded that unilateral force is generally impermissible except in self-defense. It also went to the Security Council, the institution with primacy in the use of Bellum, to try to explain why, notwithstanding that general rule, its exercise of military power was in the service of international law, specifically the prohibition of chemical weapons. Now, you might say that the United States acted unlawfully. You might think that because it acted unlawfully, its justification did not pass the laugh test. It was just cheap talk, lipstick on a pig. This logic makes sense if one thinks with the misdiagnosis that the only criterion for evaluation is whether there was a violation. But as I've been arguing, that metric is too simplistic. In the 2017 Syria incident, the United States conceded the central tenets of the use of Bellum. It accepted, even if only implicitly, that international law meaningfully regulates the use of force, that it was not entitled to attack Syria just because it could, that any justification for using force other than in self-defense would have to be in the service of international law, and that the Security Council is ultimately still the proper locus for decision-making on the use of force, even if it was not the final backstop. Contrast that approach with the one the United States took when it attacked Iranian General Qasem Soleimani earlier this year. Soleimani likely was involved in many incidents of low-level violence against the United States and its allies. Still, the US attack on him upped the ante. In the immediate aftermath, the United States mostly just thumbed its nose at international law. Administration officials vacillated incoherently about their justification for using military force. They variously suggested that the action was justifiable to deter imminent attacks that Soleimani was plotting, that it was retribution for earlier attacks, and it was just part of a broader geopolitical contest with Iran. US officials did not provide the details to substantiate any of these justifications. At times, they also trafficked in conspiracy theories and lies. The contrast between the 2017 Syria incident and the 2020 Soleimani one helps capture the third trend. The US disposition toward the use of Bellum was significantly more dismissive in the Soleimani incident. Although the United States eventually did submit an Article 51 letter to the Security Council to try to justify its action against Soleimani in self-defense, the damage had by then already been done. The clear message from the United States in the days following the strike was that the authority of international law did not matter. The United States would do as it pleased and the rest of the world would suffer the consequences. In other words, the message was all that matters is control. The United States has communicated this message in other scenarios as well. Take the US decision in April 2019 to recognize Israel's sovereignty over the Golan Heights. As discussed, this decision was inconsistent with the bedrock prohibition of acquiring territory by force. That's troubling because it's a retreat from the core of Article 2.4. It's also troubling because the United States made clear that international law had absolutely no bearing on its decision. When Secretary of State Mike Pompeo was pressed to defend the recognition decision, he contemptuously brushed international law aside. What matters, he said, is, quote, reality. Again, quoting, the Trump administration sees the world as it is, not as we wish it would be. Apparently, the international law enforceable annexations is a utopian pipe dream, unlike the reality of raw power. Again, the problem here is not only the violation. The problem is a disregard, even contempt, for the authority of international law. Pompeo is telling us quite explicitly that all that matters is control. And by the way, it's not just the United States. For example, in a number of the cases on territorial acquisition that I mentioned earlier, the acting states did not engage with the use of Bellum's authority. They did not perform any kind of discursive dance. So where does all of this leave us? The three trends that I've identified, expansive claims on self-defense, a retreat from the prohibition of territorial conquest, and the disengagement from the discursive aspects of the use of Bellum, are troubling because they together call into question the entire premise of this area of international law, that the use of force in international affairs is and should be meaningfully regulated, not left to the discretion of individual states that have the raw power to implement their own nationalistic agendas. That premise did not die in 1970 or in 2003, but it is, in my view, very seriously at risk in 2020. For those who are still committed to the use of Bellum, as I think we all should be, now is the time to lean in. We must find ways to reaffirm the central tenets of the use of Bellum, despite inevitable disagreements about how they intersect and apply in concrete cases. There's no magic bullet for how to do this, but at the very least, states that have historically been muted about their views on the use of Bellum, rarely opining on specific incidents except with bland references to the Charter, need to get more into the game. It's no longer enough for the vast majority of states to sit passively on the sidelines when militarily powerful states use force. These other states should develop and press for their own positions on the world stage. Insofar as they lack sufficient resources to do so, the rest of us should help out. For example, UN and civil society groups might advise states that have historically been checked out from the use of Bellum's day-to-day operation so that these states can more effectively develop and advance their normative visions for it. Likewise, we must find ways to harness the authority of international institutions, even when they are incapable of finally resolving the issue in dispute. Remember that the Security Council was actively involved in the 2017 Syria incident. It met repeatedly to discuss the situation, including by holding a special session on the US action. Many people would have preferred for it to have played a more active role, either to authorize or to condemn the use of force in that case. But even when the Council is too conflicted to make that kind of decision, insisting that it deliberate on and address the issue in dispute at least reinforces both its own primacy and the expectation that decisions to use force are matters of collective concern, not entirely within the discretion of militarily powerful states. That level of council engagement might not be enough as measured against some ideal. It still is better than the alternative that is now on the table, which increasingly is to recognize that decisions to use force are not meaningfully regulated by international law, that all that matters is military might. And if this alternative doesn't seem distressing to you, I'll leave you with a short quote by Michael Reisman, who I consider to be one of the great international legal scholars of our time. A system of unregulated violence is inimical to optimally productive human interaction, and of course, loathsome to all but the morally defective. We should do what we can to keep the use of Bellum from slipping into the grave. Thank you for your time.
Thank you very much indeed, Monica. That was excellent and gives us a lot of food for thought. We already have a couple of questions, which I'll come to in a minute. And if other people have questions, please put them on the screen. We have about 15 minutes or so. We need to finish soon after 7 o'clock, I believe. I'm not going to say much, therefore, just to say that I very much agree with you that having a discourse about the use of force is very important and can be very constructive. And I think it probably does happen more in the United Kingdom than it does in the United States, for example, but then I would say that, wouldn't I? I would turn the table a bit and without pointing the finger at you, Monica, say that I think one of the threats to the law on the use of force is the somewhat dogmatic and unrealistic attitude that one finds among universities and among professors. I'm thinking particularly of those in Europe, and I mean Europe, not the United Kingdom, of course. They tend to take a very rigid view. I do think that those who reject outright the thought that there can be a right of self-defense against non-state actors ought to think about what they're saying and what that implies for the real world, as you put it. More questionable, perhaps, is the United Kingdom's strong view that humanitarian intervention is permissible, which they have argued and argued at great length. And there was a great debate here about it 20 years ago when Ian Brownlee said, no way, you can't do this. Chris Greenwood said, yes, you can do this. There are precedents for this. And Vaughan Lowe, I think, got it exactly right when he said, well, not yet, but it would go with the grain of international law if ways could be found of enabling humanitarian intervention to be. So I do think professors and lecturers have a lot to contribute and don't always do so. But you have, Monica. So I'll go to the first question, which I think goes right to much of what you were saying, and it's effectively saying that Anglo-American international lawyers, but I think not only, that's my comment, repeatedly discount recurring protests from developing countries against extensive claims, even though there have been numerous and explicit joint statements by those countries. So that's a question, really. I mean, I do recall that the non-aligned movement makes frequent statements, as do others in the United Nations, in the General Assembly, among other things, making it clear they don't agree with humanitarian intervention, for example. I wonder what your view is on that point, Monica.
Okay, great. Well, thank you. I will just say I agree with you on the point that you made about international legal scholars holding on to a very rigid conception of the Charter as if that is the only conception available. And in doing so, I think at least blinding us, I mean, this is part of my thesis, at least blinding us to the ways in which the Charter might operate not consistently with that rigid construction. So I think I think we agree on that point. In response to the question, I would say it is true that the non-aligned movement and states from the global south sometimes do get together in institutional arrangements to articulate a restrictive view of the charter. And they often use that very language. We endorse a restrictive view of the charter as interpreted, for example, by the International Court of Justice. And those pronouncements are, I think, to some extent, part of what I would call the institutional code. So that's very consistent with other pronouncements that are made in international institutions. I think that they tend to be passive, acquiescent, sometimes tolerant, sometimes supportive in the face of real life incidents. And there are all sorts of reasons why they might be. This is not a way of blaming them, just like as I was not blaming the military powerhouses for taking the positions they do. They might feel like they don't want to take a strong position on the jus ad bellum in a concrete case in which a state is using military force. But that comes with a cost. And the cost is that they are not responding to the application of the law on the facts. And by the application of the law on the facts, I mean the way in which global actors are collectively using or not using what many people consider to be the law in the circumstances of a case. So I would encourage those states to be more vocal and concrete and specific about their views on the jus ad bellum, not only in institutional pronouncements, but also in concrete cases in which the use of force is used. Because those are the cases in which particular uses of force are being teed up to be legitimized or delegitimized through international law, and their silence is basically a way of taking themselves out of the game.
Yes, if I could add a question on silence. I mean, professors, and I'm sorry to keep talking about professors, seem to like to talk about everything, even before they know the facts, particularly in these days of instant blogs. We get told that things are unlawful, even before any of us know the real facts. We may never know the facts. And I think it is difficult to expect third states to pronounce definitively or firmly about circumstances when they don't know the facts. This is a question of proof. A lot of uses of force may be based upon intelligence, for example, that may never be known. How would you see that?
Good. So I mean, I think that is sometimes true. And so that complicates my reform proposal. But, even when the facts are apparent, states do not take up the opportunity to articulate their view of how the law applies to the facts. So we could take an example, take the decision to use force against ISIS in Syria. The justification in the early stages of the anti-ISIS campaign was that the acting states were acting in collective self-defense on Iraq's behalf against ISIS in Syria. At the time, the United States and I think it was 5 other states, maybe a total of 5 or 6 states, including the United States, used force in Syria. A number of other states, including many European states in the early stages of the conflict, were not willing to use force in Syria. And of the states that did use force in Syria, only the United States articulated a clear explanation of how that operation was compatible with Article 51. It advanced the unable or unwilling position. The Arab states that were part of that early days coalition to use force in Syria invoked Article 51, but they did not explain how Article 51 applied in the circumstances of this case. And then just to reiterate the point about the discrepancy between what states do in fact and what they articulate in their institutional pronouncements, these states were then part of the non-aligned movement that in 2016 reiterated a restrictive position on the charter that seemed to suggest that self-defense against non-state actors is never permissible. So we could take these 5 states and say that in this circumstance, they actually did have an opportunity to articulate a view on what the right of self-defense entails in this circumstance. And instead of doing so, they didn't, and they all, not only did they not, but they added to the confusion by apparently taking different positions in practice as opposed to in their pronouncement. And there are other circumstances like this. I mean, the 2017 Syria case is a good example because it's a case in which states actually did get together at the council to talk about what the United States did. And very few states used the jus ad bellum, the language of the jus ad bellum, to actually try to opine on that operation, even though many supported the United States. So these are lost opportunities to basically articulate a more coherent and clear vision for the jus ad bellum by states that are not themselves at the forefront of using military power, but often have opportunities to, or either in some circumstances are, or have opportunities to try to refine the law. And so it's in those circumstances that I think they're missing their opportunities.
Yes, it is, of course, sometimes politically very difficult for states to speak out in the heat of the moment. So I wonder how realistic it is to expect them to do so on a routine basis. Now, there's a question that goes back to your institutional code versus state code point. And the question is, what would it mean in concrete terms for a state to, quote, leave room, unquote, for the institutional code? Acknowledging the authority of Article 2.4 by justifying an operation as consistent with it is not enough. Is that so in your view?
I think there are different ways in which states can continue to endorse the authority of the jus ad bellum even when they're acting inconsistently with it. So again, I use the 2017 Syria case because it's an example in which I think the United States did that. It did not question the general prohibition on the use of force. It did not claim to be expanding the right to self-defense to some laughable boundary. It instead said, it acknowledged that basically that it had to craft a justification for the facts, and it conceded that its use of force would generally be prohibited, but then it said things like, in this circumstance where we have a clear violation of a sacrosanct international legal norm, which is the prohibition against chemical weapons, we have a failure to address that issue, we have an exhaustion of peaceful remedies, we have a direct and proportionate response, the use of force is, in our view, justifiable. I mean, that kind of language is language that, in my view, recognizes the central tenets of the jus ad bellum. And so that's the kind of thing that I think gives credence to it, even when states are acting inconsistently with it. Or we could take the other example I gave of the NATO-led operation in Libya. So we have a Security Council resolution 1973 authorizes states to use all necessary measures to protect civilian and civilian populated areas under threat of attack, is I think the language. And then the question becomes whether a regime change is a necessary measure to protect civilian and civilian populated areas under threat of attack. No matter what you think about the merits of that question, in other words, whether you think the regime change was or was not authorized by the council, was or was not lawful, the fact of the matter is that the states that engaged in that regime change went out of their way to explain how, in their view, the use of force was consistent with what the Security Council had authorized. And in so doing, they continued to uphold that authoritative pronouncement by the Security Council, even as they deviated from what many consider to be the correct interpretation of the law. So these are circumstances in which, as a matter of fact, the discrepancy between, again, the sources of authority and the levers of control are made apparent, but the states that are using military power are still taking steps to, as I say, engage in some kind of discursive dance to uphold the authority of the jus ad bellum and to make clear that they are not just acting in ways, in their view, that is in the pursuit of pure military power, that they are acting pursuant to a regulatory framework that exists under international law. That's a lot better than the alternative, I think, which is for them not to engage in that kind of discursive dance and not to recognize the authority of international law, and therefore that there are actually embedded within it certain constraints beyond which they wouldn't be willing to go.
Yes, I mean, the Syria case is interesting, but there was, I think, a year later, a tripartite attack on Syria in response to a chemical weapons use. And there, the United Kingdom set out in great detail its justification. It was based upon humanitarian intervention. It wasn't based on any theory that chemical weapons are somehow especially heinous and therefore we can use force. Now, one can disagree strongly with that view from the United Kingdom, but at least they made the effort to set it out. However, there's a good question here, which is asking you whether the difference between the institutional code and the state code has something to do with this difference between legality and legitimacy of the use of force. Could you say a word about that distinction?
I think a lot of people would use that distinction, the distinction being that which is consistent with the accepted doctrine or positive law as the institutions pronounce them, legality, and that which is in some ways viewed as legitimate for reasons outside the law, legitimacy. In my view, that stark distinction between that which is within the law and that which is outside the law is not a particularly useful one. So, I might draw a distinction between, instead of legality and legitimacy, legality and lawfulness, where legality is that which is consistent with the institutional pronouncements and the processes for creating the accepted processes for creating international law and applying international law. And lawfulness is a more is what things people do in the actual application of the law in concrete cases, which might not reflect what was set forth through the mechanisms of legality. That construction that I just offered, I know is very, very controversial, and I'm doing it just as we're running out of time. So maybe you'll just have to accept it. But that is how. But I would prefer not to use the legality versus legitimacy construct, because in my view, it creates a false distinction between that which is internal to the law and that which is external to the law. And I think there's much more fluidity between the two than that construction accepts.
Yes, I mean, I think if people say something's legitimate, they're admitting it's illegal quite often. But there's a question about the use of force by so many states in Syria and what the effect of those actions over the last few years have been on the jus ad bellum, to which I would add a question. The law on the use of force is flexible to some degree. It has to develop to meet new threats, I would say. And it develops through cases and through what states say about cases, through what the international community, through what professors say about cases. That's how the law develops. How do you think what's gone on in Syria in the last few years, and particularly the attack on Daesh, should be seen in that regard? I would recall that France, which had strongly opposed the use of humanitarian intervention, I think, took a very interesting view that the Daesh case, where Daesh was occupying a large part of Syria and was behaving effectively like a state, was a special circumstance. Would you agree with that?
Well, I agree with you that France seemed to change its position in the lead up to, from the time when it actually used force against Daesh in Syria to the post-Daesh articulation of its legal position. It seemed to change from a justification of self-defense to something else, or to deny that self-defense at least was permissible against non-state actors. And at least it seemed to take the position, in other words, after the ISIS operation, despite what it had done in that operation, that self-defense against non-state actors is never or almost never permissible. As for how I interpret that incident, I guess I would say that I think the incident reveals and exposes rather than resolves the underlying contest about what the proper parameters of self-defense against non-state actors is. I think the fact that a number of states were not willing to intervene in Syria against Daesh in the early stages of the war, and that the justification, one, and two, that when the Security Council seemed to condone the use of force against Daesh in Syria, it did not itself articulate a legal position on self-defense against Daesh in Syria, even as it was condoning an operation that was underway by all accounts. And three, that the states that used force in self-defense over time, and by in part citing the Security Council resolution, did not articulate the standard that the United States and the United Kingdom and Canada and Australia, for example, have articulated, which is the unable or unwilling standard, reveals that that the non-aligned movement after the anti-Daesh operation came out with a pronouncement saying, we take a restrictive position on the charter, reveals that the law that governs when states may use force against non-state actors in self-defense continues to be very contested. And the Daesh case simply, in my view, exposed rather than resolved that contest. Because even as states were on board with that particular operation, they had a very hard time accepting or articulating what the generalizable principle might be that might apply in future cases.
Thank you, Monica. I think there are quite a few further questions, but we don't have time to go in for them, and I apologize to those who've asked. Quite a few of the questions have said what a marvelous lecture it was, so that's certainly my view. And before closing, I'd like, I'd pass the word now to Martins again, back to Martins, so he can close this excellent event.
Thank you, Sir Michael. Thank you, Sir Michael. Thank you, Monica. Unfortunately, one of the drawbacks of this being remote is that we cannot thank you all in the customary manner by long and thunderous applause. And if I may make a geeky point, perhaps there's a question whether the concept of customary is a point on which chair and speaker would agree. But it was a wonderful talk. The only extraordinarily small footnote I may add is I don't know whether Sir Michael would remember it, but it was some 15 years ago on the point of law and legitimacy when Sir Michael described the views on Kosovo by various academics and then summarized the opinion of the House of Commons Foreign Affairs Committee on Kosovo as bloody, unlawful, and a jolly good thing to do. And that, I think, became a canonical way of expressing that distinction in certain circles. This has been a wonderful first lecture for this year's Current Legal Problems series, but by no means the last one. So if you are very much inclined in a Renaissance manner, be wise on all topics. And next week, you may tune in for Professor Lucina Hose from Hong Kong, lecture on mental element in equitable accessory liability, chaired by Lord Briggs, which is, I gather, if 2001 ILC articles applied in domestic law, that would be roughly Article 16A. And if you are interested in international law, on 26th of November, Anne Alford will be speaking about regional orders and international law, and Sir Michael's successor, Sir Daniel Bethlehem, will be chairing that talk. Many thanks indeed for tuning in, and please join me perhaps now, at least in some way, thanking our wonderful speaker and chair.
Thank you, and thank you to you both for being here and to all of you listening from home. It's really been delightful to engage with you.